How you doing today? We're going to give you a presentation on musical copyright infringement protection. I'm Nick Burrow.
And I'm Nick Cisparo.
We represent Business Law 2150 at Appalachian State University, taught by Dr. Parsons. This recording was given on April 21st, 2015.
Nowadays, you can't even go outside without seeing somebody with headphones in their ears, listening to their favorite music. There's over 20 different types of genres of music, and each one has subcategories. An example of this would be the genre rock, and subcategory could be classical rock. So, what is copyright? Copyright can be defined as the exclusive legal right given to an originator or holder to publish, perform, film, or record material, and to authorize others to use the same material. The Copyright Act of 1976 has been in effect since January 1st, 1978, and still remains the primary basis of copyright law in the United States today. This act gives the basic rights of copyright holders and codefines the doctrine of fair use. Fair use is a doctrine that permits limited use of copyright material without acquiring permission from the holder. Examples of fair use could include search engines, criticism, parody, news reporting, research, teaching, and scholarship. Music is such a major cornerstone in our society today. Every day there's new music being released, and complete originality of music is so difficult to accomplish because there's only 12 unique named tones in the music industry. This relates to business law in a variety of ways. Music is one of the biggest businesses in the world, and where there's business, there's also legal matters to attend to. Music involves laws such as contracts, copyright, and civil suits involving intellectual property. Here we've provided a few cases that have been up for dispute in the past 20 years. The first one involves Michael Jackson. The second case involves Curtis Jackson, otherwise known as 50 Cent. And the third one, being the most recent, involving the hit song from a couple years ago called Blurred Lines with Robin Thicke and Pharrell Williams. In Cartier versus Jackson, Cartier could produce no evidence that found Michael Jackson liable and had no knowledge of her original work. in in the case involving 50 Cent's single In the Club, there was a disputed phrase, "It's your birthday," and this was deemed as unprotectable because it's such a common musical and lyrical phrase that has been used in prior works. "It's Your Birthday" was therefore not independently created by Ween. And lastly, in the case involving the hit song Blurred Lines, Marvin Gaye's family was just awarded about $7.4 million because they found Blurred Lines used the same groove as Gaye's song Got to Give It Up. And now Robin Thicke and Pharrell Williams are going to appeal, which is an ongoing process.
Now getting into the legal issue that we focused on. Our legal focus is on the evolving music industry and the use of sampling in this industry, which has become popular in modern day music. What is sampling? Well, sampling is the practice among popular musicians of lifting portions of an existing sound recording and using them as a component to a new song. It involves sequence of notes or words that have been previously recorded. This is illegal not because the copyright of the music composition, but because of the copyright to the sound recordings. The way around this is as simple as avoiding the original sound recordings of a song and completely reproducing the sound on your own in your studio. Now I want to talk about a case that involves sampling. This case dates back to 1991. It involved Grand Upright versus Warner. two artists in dispute were Raymond Gilbert O'Sullivan versus Biz Markie on the song Alone Again. The court ruled in favor of Grand Upright, stating that the defendant had clear knowledge that he was violating the plaintiff's rights as well as the rights of others. Their only aim was to sell thousands upon thousands of records. The judge based his opinion on three premises. First, that the plaintiff was indeed the true copyright holder of the original work. Second, that the testimony of Gilbert O'Sullivan, the acknowledged writer of the composition in question and the performer who was featured on the master recording, pirated by the defendants, and three, the defendant's actions both before and after the insurance of the defendant's album and contacting Gilbert O'Sullivan and his agent attempting to obtain a license to use the copyrighted material. The judge of this case, however, did not give his ruling based off the copyrightable material that Markie infringed upon, the three words and accompanying ostentio, rather than the song was potentially demeaning to the plaintiff's original piece. Now let's dive into some scholarly analysis of some law reviews. The first law review that we're going to touch upon is a law review presented by the Baltimore Intellectual Property Law Journal, presented by Diane L. Kilpatrick Lee. Copyright infringement laws include literary works, musical works, dramatic works, choreographed works, motion pictures, sound recordings, and architectural works. Kilpatrick Lee states that the purpose of criminal copyright statute should be to prevent copyright infringement because it is morally wrong. It is morally wrong because the infringer is taking from the artist or creator, reducing the economic incentives for that artist or creator, which results in a loss of future works and creations, ultimately harming the community. We respectfully disagree with Ms. Kilpatrick Lee's opinion on this matter. We believe that infringing upon these copyrights is not meant to take away from the original creator by any means, but only to provide a basis to build off of for new artists. As humans, we have not only advanced because of new innovative ideas, but from the advancement of building upon those ideas. Music is built off of a similar premise, and that using original artists' recorded ideas to formulate another artist's perspective on that idea only furthers music's reach. We encourage artists to create their own ideas, but also to continue advancing the ideas of artists that become before them. Doing this is another way to keep artist music alive and relevant. Ms. Kilpatrick Lee went on to give a new approach that would help both sides of the argument, stating that maybe a better approach to fight the infringement that has worried everyone in Washington, D.C. is to include a copyright tax on purchase of products that can be used for infringing purposes. The tax should not be too high, and it should be collected by an industry agency that would divvy out the tax equally amongst the copyright owners. We agree with Ms. Kilpatrick Lee's opinion on this matter to an extent. We believe instead of a tax that is given to the consumer of a product, that there should be a sample tax given to the artists that want to use a previously recorded sound piece. This tax should not be too high, and it should be more than fair for both sides. Both Ms. Kilpatrick Lee and the copyright law states that the purpose of copyright protection is to further knowledge and learning. We disagree with this statement because the current state of law does not encourage others to further their knowledge or learning, but rather to keep an idea stagnant. The next scholarly analysis is from Notre Dame Law Review, given to you by Mayo B. Aurora. Aurora states that the authority for copyright thus impedes two key concepts that have long been the focus of intellectual property scholarship: progress and innovation, and the rights of authors. We agree with Aurora's point about copyright law impeding the progress and innovation, especially in talking about music. We believe that the artists were not bound to such strict laws that more and more great music would be made every day. Every artist is different and has a different take on the music they create. Imagine what they could do if they were free to bring their own take on music that has previously been recorded. We believe that peeling back the strength of these laws will provide artists more freedom to create. However, we disagree with Aurora's point that states that laws involving copyright impede upon the rights of the author. These laws are aimed to protect the author or the holders of a copyright, and though the work deserves protection, we believe that the law provides them with a bit too much. Aurora also goes on to say creativity is one potential metric by which to measure artist innovation. However, conceptions of creativity and law remain nebulous and in many instances incompatible with actual creative practices in varied contexts. Arua believes that the copyright law takes away from innovation and artist creativity. We agree with him that copyright laws in music contexts impedes artists from their creativity. As humans, we thrive from building ideas, and an idea is meant to be built upon. Blocking artists from sampling other artists' music is taking away from great music that can be made in days to come. Arua also states that the laws are vague and not compatible with today's musical practices. Again, we agree with him. We believe that the law should be amended in the way that will help the practices in modern music. In the past, the law has been amended to keep up with the times. We believe that it is time to do this once again. Sampling is a very popular practice nowadays, and there should be a system set in place for this theory that is both practical and fair for both sides. In conclusion, we feel that today's copyright law is too strong and should be peeled back. We also believe that there should be a system set in place for artists to feel free to sample from other artists without feeling confined by the law. Thank you for your time. This has been Nick Burrow.
And Nick Cisparo.
Thank you for listening. Here's our Works Cited page.